Hello and welcome to the pre-council meeting of the Lincoln City Council. We are gathered here today to talk a little bit about reasonable accommodation.
Yes.
So, Mr. Christie, please take it away.
So Miss Luttrell is here, and she has a PowerPoint. This will be a brief, general overview of how this works. We're not here to talk about any specific case or specific matter. Again, just a general overview, and we'll answer questions as well. So, thank you.
Good afternoon. Abby Luttrell, Assistant City Attorney, and we've done this before, some of the tenured City Council members, but thought it would be good just to review this kind of unusual matter that will be before you occasionally, and this is request for reasonable accommodation to the City of Lincoln as an entity. So what we're talking about is the Federal Fair Housing Act. This is Title 8 of the Civil Rights Act of 1988, amended in, Title 8 of the Civil Rights Act of 1968, amended in 1988. That's Ronald Reagan, extending the protections of Title 8 for housing to people with disabilities. We are also subject to the Nebraska Fair Housing Act, which is just the state level. Complaints, violations of the Nebraska Fair Housing Act go to the NEOC, Nebraska Equal Employment Opportunity Commission, and my colleague Marna Munn is here. We're really lucky to have her. She was the director of the NEOC for several years, and so she's a great resource for this area and all things discrimination related. The Federal Fair Housing Act prohibits municipalities like ours from making basically any decision that would exclude or otherwise discriminate against people with disabilities, whether intentionally or just by having a discriminatory effect. One of the main concepts I really want us to be thinking about is that when you are making decisions about reasonable accommodations, no court is going to care what your intent or motivation was. It is only about whether the person is entitled to that accommodation under the law. And so we may have lots of information to say, hey, we had this public hearing and we had 50 people from the neighborhood show up and talk about how this was going to impact them, and we wanted to help those people, and that's why we made the decision that we made. That is not going to matter to a court. Good intentions do not alleviate us as a municipality of our obligations under the law. Part of why this is so tricky and it's hard for us to even talk to you about and staff to come up and present these cases is because usually when you see a matter on your agenda, you're being asked to make a policy decision or kind of a growth decision for the city or weighing the interests of different parties. And when a reasonable accommodation request comes to you, you really are acting more like a court would act. So you're not making a policy decision. You are evaluating the evidence in front of you and saying, federal law says we have to do this under these circumstances. Do these circumstances rise to the level where the law requires us to do that? So I think it's just helpful to keep that framework in mind because it's really hard to take on that role that's different than 99% of what you do. So a reasonable accommodation, this is just boilerplate definition. It's a change, exception, adjustment to a rule, policy, or practice that may be necessary for a person with a disability to have equal opportunity to use and enjoy a dwelling. And those are the magic words, equal opportunity to use and enjoy their dwelling. I won't read this whole thing, but it's essentially getting to the point of we're not talking about treating people equally under a neutral set of laws. This is one area where federal law requires the city and lots of other people, landlords, real estate agents, to do a little bit more. It's an affirmative act to raise people with disabilities to a level where they can equally enjoy their dwellings just as everyone else has a right to. This is just a definition under the law of what a disability is. This will be the easiest part for you. We will usually be able to come here and tell you whether the person meets the definition of disability under the law, so you won't have to worry about that much. This is our process for making and processing these requests. It's found at 1.28 of the Lincoln Municipal Code. So there's a form that people can access on the internet. They turn it into the clerk. The clerk then refers it to City Council. It appears at that beginning part of your agenda, so you'll know it's coming, but you are referring to the reviewing authority. The reviewing authority will depend on what kind of accommodation they're asking for. So if it's a zoning accommodation, it will go to the Planning Commission as the reviewing authority. If the individual is asking for an accommodation to the building or housing or fire code, it will go to those appeals boards before it gets to you. They'll review, and it'll come back to you to make a decision after a public hearing. I won't read through all of these. You can find them in the code. You'll get a staff report that does some analysis of this, of all the different factors you are to consider on whether to grant or not grant the accommodation request. There are three, the case law tells us that there are kind of three buckets that we're looking at. The accommodation requested must be reasonable. It must be necessary. That's either therapeutically necessary or financially necessary. And granting the accommodation must ensure equal opportunity to use of the person's dwelling. Where that will come into play is that there are some cases that talk about the requested accommodation isn't just providing equal opportunity, it's providing more than equal opportunity. So it's hard to think of an example, but so a disabled person wants to have a commercial or a commercial use in a residential district, like they want to open a Target in the R2. That would not be, it would be hard to define that as reasonable or necessary, but also it would be introducing something that's more than equal to the rest of the population. There are essentially two grounds for denial. If all three of those requirements are met, if it's an undue financial or administrative burden, or a fundamental alteration to the nature of the law or policy. If one of these is present, then staff would talk through what may reach that level, and you may receive information about that at public hearing. So it's usually easier to learn from examples. So I just pulled, we've had more of these in the last 2 years or so than I think in the last dozen years combined. I always start with this one. Back in 2007, we have some experience, the City of Lincoln does, in the court system with reasonable accommodations. This was a case in federal district court in 2007. Developmental Services of Nebraska requested an accommodation to the 3-person rule. For group homes, they asked for 4 residents in a residential neighborhood. Planning Commission recommended denial. City Council also, ultimately denied the request. I won't read this whole thing either, but the crux of it is that we got beat up pretty bad by the judge in federal district court for not granting that accommodation. The court said that the evidence showed that the requesters were entitled to it, and that the last line there, as a result, taxpayers will have to pay the provider a lot of money for the violation. And we did. Yes.
Why did the judge say, not just sadly, but what was the reasoning for why we lost? Did he say that we were unreasonable? It was, could you just say that?
They said that it was unreasonable for the city to deny the request, that DSN of Nebraska put on sufficient evidence that that the request was necessary, it had therapeutic value, that there was no fundamental alteration of the zoning scheme, that there was no direct threat to anyone else, and that I think the line there was heaps of red tape garnished with bureaucratic indifference and inconsistent, irrelevant posturing by city officials.
Whoa.
I'm not familiar with the case. Can you explain what that case was, or give me?
Sure, it was Developmental Services of Nebraska. They're a organization that helps people with physical and intellectual disabilities, and they wanted to open a group home in a residential neighborhood with 4 residents, unrelated residents. They asked for a reasonable accommodation to that part of the zoning code, which is probably the most common request that we've been getting. With the new changes last year with that legislation, we may see less of that, but we still may see requests to waive that limitation of unrelated people living together. So they said it's necessary for us to have this communal living. It's financially and therapeutically necessary to do that, and they asked for a waiver. And the city council at that time in 2007 said, no, we are not going to grant that reasonable accommodation because we think that our laws are important and it's important to treat everyone the same. I think that's what the record in that case mostly was we're not discriminating against you. We're treating you just as we're treating everyone else. But the law says we have to do more when the facts support that.
Thank you.
Yep. This was a judgment that was entered in 2007. This is $2007. I can tell you just the climate of this kind of litigation has ballooned in the last 10 years, that we could expect, if found liable, judgments of at least this much, up to two or three times as much of this. And what really can be painful and can be the brunt of damages in these cases is attorney's fees. Because if they collect $1, they generally can collect most of their attorney's fees. And there are smart, capable attorneys that practice in this area. You may remember Lucy, the potbelly pig. This was a request that came into City of Lincoln in 2022, and Lucy was an emotional support animal for residents in our city. This was a really well-developed application. The applicant had documentation that he was a disabled veteran, that the animal really provided therapeutic value, that caring for the animal on the property was not a danger and or something that was kind of furthering this person's disability. There were also no complaints from the neighbors, and the pig is adorable. So this was the resolution, and this is what resolutions will look like. When you see them on your agenda, we are always going to draft them in the affirmative. So just like anything else, just because you see it on the agenda doesn't mean that the recommendation from staff is that you approve it. It's just that if you did approve it, this is what it would look like. And they're all pretty similar. We try to make them as specific as possible, because that's the other thing, that reasonable accommodations are really need to be evaluated on a case-by-case basis. You'll see similarities between them, but we should be looking at what facts do we see for this case. So this was a waiver. There's of the code section that says you can't keep swine in the city of Lincoln, and we said your accommodation that yes, you can. And then sections 2 and 3 really keep that narrow. It's only for this pig, it's only for these people, and it's only for this address. If any of those things change, the reasonable accommodation is rescinded. So unlike other land use actions that you take that ride with the land basically forever, we draft these so that they're very specific. Pretty soon after that, the Oxford House made an application. Oxford House is a national organization, long history, a lot of litigation with the Oxford House, where they were asking for, I forget how many people, 14?
I thought it was 19.
14. This is the final resolution. It may have been initially 14, and then they, yep.
Okay.
Those of you that were here will remember what those hearings were like. Lots of people with sincerely held beliefs come and give testimony from both sides. So you'll receive lots of evidence, and a voluminous record is created. In this case, the council determined that the reasonable accommodation request should be granted. And I just want to mention a few things on this one because I think we can compare it to what I'm going to talk about next, the case that came shortly after that. The public hearing on this request for accommodation had a really good record of what Oxford House had done. So there was testimony about percentages of people who recover. There was testimony about how many times the police had been there, what the parking situation was like. So it was really a robust record for the council to be able to find that the elements of the accommodation request were met. And I think that's probably typical of Oxford House because they do this across the country. Not long after that, well, we had a couple of Michael's House ones. I want to talk about the one from February. February of 2023, there was a request for reasonable accommodation at Michael House, which is on, where is it, 27th and Washington-ish. And in contrast to, I think, that Oxford House hearing, these are just some quotes that I pulled from the Journal-Star. There was testimony that the Nebraska Parole Administration had removed all of the residents from the house just like days before we had that hearing. And then there was lots of talk about like what were the services being provided, what was the therapeutic value, and the reasonable accommodation request was denied. What I like about these quotes were that created a record of that we in the law department can defend. We had evidence that this was not therapeutic, that this didn't have a therapeutic value. Nebraska Parole had pulled people from there. That kind of evidence is much stronger than we had a lot of neighbors that didn't like that there were 10 people living in the house. Do we want to pause there? Any questions or discussion about kind of those three case studies? What
Questions for Abby?
Mr. Chairman. Mr. Rochelle, thank you very much. We saw a bunch of these in a row, and I'm hoping that our new changes in our ordinance will reduce those numbers. But this is not what I do every day. I don't understand this. And I don't know how to ask you and the law department the questions to inform me. Are there questions I should be asking you?
Well, you all know you're welcome to, we can give confidential legal advice at any point when you see one of these come. Please call me or Johansi or Marna or anybody in the law department. And really, I think when I read the case law on this, I think our council does a really good job on handling these reasonable accommodations requests. We have a process in place. Our elected officials are really well informed. And when I read other cases from across the country, it's kind of appalling how, they get themselves in trouble just because they're like, what is this? This is so different, and they don't know what to do. And so this council is really good. I think just asking good questions of the applicant and the opponents, and before it comes to you can reach out to planning or LPD or any department that's involved to gather more information, to get that information onto the record, because that's really what we're trying to establish is we made this decision and these are the reasons why. And you can look to this testimony and you can look to this document, and that record is what will enable us to defend your decision.
Thank you. Thank you, Mr. Chair.
Any other questions for Abby? Okay, let's continue on.
So here at the end, I just kind of close out on what happens if we deny a reasonable accommodation request. There's a number of ways that the law can be enforced. One is through administrative complaint. So the U.S. Department of Housing and Urban Development receives these complaints. Department of Justice receives these complaints. The NEOC could receive these complaints. Those are investigated by people from any of those jurisdictions, and then they have authority to bring a lawsuit. So HUD could sue the city of Lincoln, Nebraska to enforce the rights of someone whose fair housing rights were being violated. So could the state of Nebraska, and then the individual themselves or the organization would have grounds to bring a civil lawsuit in state or federal court. And then if any of you are interested, really kind of the Bible on this is this joint statement between HUD and Department of Justice on local land use laws. I think I've provided it to some of you in the past, but if you'd like it again, you can Google it, or I'm happy to provide it to you. Okay, that's what I got.
Perfect. Thank you, Abby. Will you be emailing us this presentation as well for our reference? Is that something we might be able to get?
I can, and I took this one from a much longer one, so I'll send the longer one, and I have some cases too that I can send it to you. And this presentation has been given to community and neighborhood groups too.
Good.
That's interesting. Can I ask a question?
Please?
Abby, when you say that you've given this presentation to neighborhood groups, has this been in the last couple of years that neighborhood groups have asked for this?
Yes.
And can you tell us who you've given this to?
The most recent one was the, what's the one by the Law College?
Echo.
Oh, Echo,
Yeah.
East Campus.
Yes. And they were very interested and receptive. I think a lot of people are just curious when they see these come up on what it is. And I think with a little bit of education too, that the reception has been pretty good.
While I did not do it justice, I have also used her presentation. I think it was within the past few years, couple years, and I believe that was the Near South. Again, not sure I did it as well as she would have, but we also did the presentation to them as well.
Yeah, I think this could be really helpful for residents to, I mean, maybe the shorter version or something would be, but I think it could be very helpful for residents, because when they come with deeply held personal statements of belief, emotional, I think it becomes harder for them to understand our role as sort of doing the job of a court instead of doing the job of a policy
Yeah,
council.
I'd like to have just a copy of it just as a PDF, just in case someone does contact me and I can say, hey, here you go.
Yeah, I mean, unfortunately, it's sometimes, we're
Especially the money slide.
Yeah.
the money slide, yeah. I mean, this is just, it's counterintuitive to tell people, like, yeah, sometimes we are obligated to waive our laws because of the supremacy clause, because of superior laws, which is hard for people to hear. So,
Have you come across, though, where you grant an accommodation for one person, and then all of a sudden, other people move into the property that don't deserve the same?
So we try, when we're crafting these resolutions, to make them very specific. So, for example, the one for the Oxford House, the applicant in that case, the waiver is for Oxford House. It's not for each individual in the house. But we do say in the resolution, every person who resides there must be disabled, and people in recovery from drug and alcohol substance addiction is disabled under the law. That's clear, black letter case law. And so if not everyone who is living there meets that definition, you need to report it to, I think it's to the planning director right now, and as grounds for rescission. It's always a question of enforcement, how exactly
Right.
would we know? But we do what we can to write it in. And neighbors are usually paying attention.
They are. Neighbors are definitely paying attention.
Yeah. So,
Yeah.
Other questions for Ms. Luttrell?
okay,
Okay.
thank you.
Thank you so much. Is that the
That's it. I think that
totality of
everyone
what
else
we
who
have
was-
today?
I think
Okay.
everyone else who was here was just ready and able to answer questions. Yeah.
Okay, very good. I just wanted to make sure we were covering the material that we were supposed to be covering today.
Yep.
Okay,
All right.
very good. With no more questions, we are adjourned. Thank
you.
you.